Welcome to Avoiding Legal Trouble with Oregon Realtor Forms. The point behind this training is to explain certain changes that you might find within the Oregon Realtor Forms that are different from other form libraries you may have used in the past. When the Oregon Realtor Forms were drafted, it was a combination of staff attorney drafting and a task force comprised of principal brokers providing feedback, as well as commentary from specialists and practitioners who did very distinct elements of the practice, as well as title companies and escrow officers and people from other adjacent industries. This form library has some very distinct changes that were made based on essentially more than a century of practitioner knowledge, as well as the archive of legal hotline responses that we receive over time. The benefit of having the legal hotline is that we, the association, can see when things aren't working in transactions or when documents have provisions that cause problems, because we hear about it on the hotline when somebody has that problem arise. And so many of the changes were developed largely in response to problems that people had run into in the past. And the point of this training is essentially to show what problems there are that are being fixed through changes within the forms. We'll start it off in the following format. I'll always start it with an issue, and we'll do a scenario. Broadly generalizable scenarios. They're not based on any specific person's scenario. It's an example. We'll then talk about how that issue creates some sort of a risk, either legal risk or a transactional risk or a practice risk, and how the Oregon Realtors forms address that problem. And if necessary, we'll show you how to fill out the form. The first issue is related to advisories. The scenario in this image on the right is a forget-me-not. A scenario is that you represent a buyer. You're a buyer's agent, and the buyer wants to make a purchase on a property. The buyer makes an offer on a property with all their normal packet of documents, and the seller counteroffers and says, hey, you need to add a well addendum. This property has a well. Sorry, didn't put it in the listing information. Forgot about that. But yeah, there's definitely a well, and you're going to need a well addendum. And also, it's a historic property. We put a whole bunch of money into the preservation plan, and it's historic because the buyer's offer was good, but it was missing those pieces. They like the buyer's offer, but they're counteroffering to add those chunks. The buyer accepts the counteroffer. They're so excited to have this house. And then halfway through the transaction, your buyer says, hey, so what is a historic property? I want to know more about it. What stuff are we dealing with in historic property? And you realize I completely forgot to hand them the page of document advisory about historic property. I didn't give them the advisory document about wells because I was using advisories in a spread format. What the Oregon Realtors Library did is mix that all together. Now, if you have advisories that are disparate and you're only using the advisories you see as necessary and you're picking from a list of dozens and dozens of advisory documents, there is a very real risk that you accidentally don't provide an advisory that you were supposed to. You forget to give an advisory. Now, the purpose of an advisory is to give the client information before they run into the problem, so they make informed decisions. The buyer knows what the risk is of buying historic property before they buy historic property. They know what it means to have a well before they look into purchasing a property that has a well. Once you're under contract, you can't just back out because you didn't get an advisory from your agent. Instead, that creates a problem. Failure to deliver an advisory to a client is likely punishable under 696-301 subsection 15 as an action that is below the standard of practice. But nonetheless, having advisories spread amongst a dozen or more documents just creates the added risk that someone accidentally does not provide all the advisories they needed to because they were trying to cut out extra paperwork. If you're telling a client something in advisory after they're under contract, you're essentially saying, here's some stuff I wish you had known before you accepted the contract, and that's really not good for you. So post-contract advising is bad. And forgetting a contract means you may be stuck with having to do some post-contract advising. And we don't encourage that. So what we did in the Oregon Realtors Library is we put all the advisories in one single document. It's all in one place. Now we understand that creates a very large document, but by sending that one document, you have ensured that you have sent every advisory. It ensures that you are not accidentally leaving out information about cross connections. It doesn't mean that you're going to accidentally leave out information about love letters. You have already provided all of that information with a single email. And we'd encourage you to still go over this with your client. They need to read it and understand it, but there's no forgetting. You can skip over the sections that aren't applicable. Hey, client, you don't want to buy a houseboat? We can skip over anything that says anything about a houseboat. No problem. But you do need to know all of this advisory information otherwise. Now, the advantage here is you can just send this to your client. A single comprehensive advisory at the onset of the transaction covers you. Tell the client they need to go back to it throughout the transaction. Hey, if you have questions, check the advisory. If that doesn't make sense, ask me questions. I'm here for you. But the advisory gives them all the information. You can have your client sign an acknowledgement at the end of the document. It becomes a proof for you as the agent that shows I delivered all of the advising information I was supposed to. It's very difficult to have someone come after you afterwards and claim my agent failed because they didn't tell me about the risk that is posed by buying historic property, because now I'm finding myself paying all these back taxes. You can then say, no, we did go over the advisory. You signed it. You initialed the page that shows exactly information about historic properties and what to think about and what risks they pose. That protects you as an agent. It protects the client by giving them the information so they can make an informed decision. It protects you as an agent by ensuring that you can prove that you did your job. Now, issue 2 is mandatory inspections before you can terminate. Some contracts will require that you have an inspection before you're allowed to terminate. For example, a sales agreement only permits the buyer to terminate if they disapprove of the property based upon 1 or more inspection reports. 2 days after the buyer's offer is accepted, the buyer gets their dream job in Sheboygan, Michigan, and they just need to terminate. They're moving to Michigan. They don't want to be here anymore. So the buyer hires the cheapest and fastest inspector they can possibly hire. The inspector does a slapdash look at the house and then sends them a report that says, this house is great. There's literally nothing I could find wrong with it. It doesn't happen often, but let's pretend it does. The seller literally says, I see nothing wrong. My inspection says this house is perfect. And the buyer sends that inspection report to the seller and says, I am displeased with this house. Please see perfect inspection report as my reasoning. I disapprove of the perfect inspection. It's a Trojan horse termination. The buyer's reason for terminating is really more so that they say, I need to move out of state. I need to go elsewhere. This house, this property is not sufficient for me anymore, but they're sending the inspection report nonetheless. The problem here is that the seller is going to reasonably say, the buyer didn't disapprove of the inspection report. They just disapproved of the transaction in general, and they're using the inspection report as a way to get out. They're lying to me. And the buyer is out several $100s because they had to get an inspection. And the seller is upset because they feel they're getting lied to. And the earnest money is probably tied up because the parties are fighting each other. So just by the fact that you said you have to send an inspection report to get out based on this early termination for diligence, you created this problem. Legal and ethical futures abound. The buyer in the Oregon Realtors forms can terminate for any reason during the due diligence period. You don't have to do pretextual inspections to justify your termination. You can just terminate. We've set it up so that the buyer has a period of time called the due diligence period, during which time they can do inspections, but during which time they don't have to only choose the inspection as their reason for the termination. The buyer can look into all things. If they look into the zoning and say, I wanted to make an Airbnb out of this house, but it turns out I can't in this zone. This house doesn't do what I want it to do anymore. I don't want to purchase. If you're within your due diligence period, go ahead. You don't need to provide a reason. You can just terminate. The buyer's due diligence period still allows them to do inspections. That's still there. They can still do this, but all they have to do is send in the notice of termination and say, I want to terminate, and we're still in the due diligence period. If that's the case, no questions asked. Move forward. The contract is over. Scenario 3. Scenario is that the seller and the buyer are under contract. The buyer requests that the seller replace a hole in the wall where there used to be like a wall-mounted television, and that wall-mounted television was removed in the past, and there's just this big sawed-out hole in the drywall, and the seller says, yep, no problem, I'll fix that. They hire their friend who's a contractor, and the contractor friend does a bad job. He repairs it poorly. The buyer gets notice of the completion of repairs and says, great, I want to look around the house. And they look around the house and they see the bad drywall job. It's obviously done poorly. And they say, this was not done right. I'm not pleased because look at how bad this drywall job was. At that point, if the seller refuses to redo it, the seller can very reasonably argue, no, I already did the repair you asked me for. So what the buyer wants out of a repair and what the seller wants out of a repair is oftentimes very different. The seller usually wants to do the cheapest, easiest repair, and the buyer usually wants the most comprehensive, high-quality repair. And those two things don't always overlap. And so when your form only requires that the repair be done in like a workmanlike manner, and that's an abstract term that nobody's really following, and it provides no further steps for reinspection, just you can look at it. If there's any conflict over that repair, it usually can only get resolved through a lawsuit or a dispute resolution. In the Oregon Realtors forms, we've set up an additional step. Buyer, once the repairs are done, the seller will tell you. They'll notify you. The repairs are complete. Hooray! After that, the buyer has a right to go back and look at the repairs. And if they think the repairs were done poorly, they can send them a notice. Hey, seller, you did not do the repairs appropriately. Please see the evidence I've provided. these repairs were not done well. If the buyer provides that evidence, it sets off a correction period. Seller, you now have X number of days to fix the repairs that were done poorly. It's an obligation on the seller to fix those repairs. If the seller doesn't fix the repairs, otherwise they don't get it corrected, or they can't prove to the buyer that it already has been corrected, the buyer has a right to terminate the contract. They can back out because the repairs were not done appropriately. Now, if the buyer is just using this pretextually and they're saying, well, seller, even though the drywall looks fine, I think you did a bad job and I want out, the seller can come after the earnest money. There's no denying that at that stage because the buyer has essentially defrauded the seller. But ultimately, this means that there is an extra step where the parties can go over the small or minor errors that occur. And if there are small or minor errors that the parties can fix, there's a process for addressing those problems. If the buyer wishes to invoke the correction period, they have to provide specificity. They have to actually explain what was wrong. They can't just say, I don't like it. They have to say, I don't like it, and here are the reasons why. The drywall is not up to code. There are still holes. I saw spiders crawling out of the hole in the drywall, even though you said it was fixed. That's a problem. You can explain the reasoning, and it becomes much easier for the seller to then come up with a solution because the buyer has provided a baseline of what they think is wrong. If the buyer says it's not done up to code, the seller knows to look at the code. The fourth issue that we address in the Oregon Realtors forms is automatic terminations. So here's your scenario. A buyer is under contract, and they're using a Fair Housing Association loan. The buyer fails to qualify for the FHA loan. The property fails to qualify for whatever reason. Could be some issue with the deck or some issue with the house. The buyer notifies seller that the loan has failed, and the parties begin negotiating to reach an agreement about their next steps. The buyer wants to use a conventional loan. The seller is uncertain if they like the idea of that conventional loan because they've had bad dealings with the bank in the past, something along those lines. The parties ultimately do agree to let the buyer use a conventional loan, but this is many, many days after the notice that the loan had failed. They're 10 days out. It took 10 days for the buyer to line up the right lenders and for the parties to talk back and forth about which loan they should use and ultimately 10 days for the parties to agree that the buyer should use this other form of a loan. The seller at some stage later on is upset with the transaction. They don't like how it has gone down. They feel like the buyer is lying to them about something else. And so the seller says, I actually want to terminate. Because if you look at our sales agreement, it says, you send me notice that the loan failed, and within 2 days, the contract fails if we haven't renegotiated, if we haven't come to a solution. We didn't come to a solution until well beyond that period of negotiation ended, so the contract automatically terminated. We were agreeing on a financing remedy, but we were so late in doing so that the contract automatically ended itself. When a contract says that it automatically terminates, that's not up for discussion. It's not up for dispute. It's not a maybe clause. Automatic termination means the contract automatically terminates when certain things occur. So if there is something that says, if you must come to an agreement before the end of this short 2-day window, and the parties don't come to an agreement, and it says it automatically terminates, you have automatically terminated. The contract doesn't exist anymore. Even if you came to an agreement later on, it's not the same contract that you're dealing with at that stage. And so there is significant uncertainty about how the transaction is supposed to proceed, and it increases the likelihood of dispute because both parties, both the buyer and seller, would have very valid grounds for arguing why they do think or don't think the contract should still exist based upon the term automatic termination. What the Oregon Realtors forms do is we do not automatically terminate. We very expressly and very intentionally removed all automatic termination. You have to very, very intentionally kill your contract if you don't want it to exist anymore. For example, consider the sales agreement financing contingency. The buyer has their financing fail. They have a right at that moment to say, seller, I just got notice from my lender. I can't buy this house. The loan has failed. I have a right to terminate right here. Lovely. If the buyer doesn't terminate and they just say, hey, seller, my loan failed. Isn't that strange? I'd still love to buy this house. Let's see if we can make it work. We set off a mandatory renegotiation period. For a period of time, in this case, 2 business days is the default. You would talk with the seller and try and figure it out. If you get to the end of that period of time, the financing renegotiation period, both the buyer and the seller have a right to terminate for 2 days. So buyer said, hey, my loan failed. But I still want to buy your house. Great. 2 days, we're going to talk about it. End of those 2 days happened. We didn't figure it out. Now we have 2 days to potentially terminate. Buyer and seller both have a right to terminate. Let's say neither do. If neither party terminates, at that point, you're in a contract. The contract has not been terminated. We treat that as a waiver of the financing contingency. It basically means because the buyer didn't use their first 2 chances to terminate and the seller didn't use their 1 chance to terminate, we are going to assume that you're working it out and that the financing contingency is not going to be present. This makes a high-risk transaction, but it ultimately means that you won't have a contract that fails through automatic processes. Instead, it fails through a party's own refusal to terminate. What this essentially means is the agent's exposure is much less. They do need to explain to the clients, if you don't want to renegotiate with the other party, you need to actively terminate. Don't wait a whole long time expecting things to work out. There is a strict timeline, and terminate within that timeline. If you want it to be a longer timeline, we can write that in. If you want 10 days to renegotiate, we can amend this portion of the contract and change the amount of time we have to negotiate for a placement loan. But if we don't come to a conclusion on that loan, if we don't come to agreement, we can terminate the contract, and we should, because we don't want to be stuck in a situation where the contract automatically terminated, or we don't want to be stuck in a situation where we're moving forward unintentionally or without the intent to actually be under contract. Issue number 5 is with withdrawable termination agreements. The scenario would be as follows. The buyer's under contract. They're 7 days into their contract. They're doing their inspections. Everything's going swimmingly. The appraisal contingency says you got to order your appraisal the day after due diligence is over. So 1 day after inspections are done, order your appraisal. That's a buyer obligation. And the seller decides they don't want to sell to the buyer anymore. The market is improving. They could sell to somebody else for way more money. It's 2020 and the houses are just going for crazy amounts again. And so the seller sends a notice of termination. They just say, hey, buyer, I want out. I'm terminating the contract. I don't want to be in this anymore. The buyer looks at this termination. They say, gosh, I don't feel like this is appropriate. The contract doesn't let the seller terminate because the market is improving. I don't feel like this is appropriate. And so for the next week, they spend time contacting an attorney and trying to figure out what the issue is. During that week, the inspection period has ended. The buyer didn't order an appraisal, even though the inspection period ended, because they're not sure if they're still under contract or not. They're still talking to the attorney. At that point, the buyer goes, seller, I don't think this is appropriate. I think your termination is not valid. So I might seek specific performance. And the seller goes, you're right. Based on my termination agreement that says I can withdraw this at any time, I withdraw that termination agreement. You're right. I was not correct to terminate just because the market was improving. So as a result, I withdraw my termination agreement. However, buyer, you didn't order your appraisal, so I'm going to terminate now because you failed your obligation to order that appraisal. Bad luck. Essentially because the buyer was stuck in the questioning part, the fog of war, where they don't know if they've terminated or not, and they suspended their obligations. The buyer has cost themselves a contract. They have gotten themselves in trouble because now the seller has a pretty valid reason for terminating. The buyer didn't order the appraisal. They were supposed to, and they didn't. A termination that can be withdrawn is a mutual contract, and it does not take effect until all parties agree to it. There's even some Oregon law that says a termination that can be withdrawable, that says I terminate but maybe not, is not a valid form of termination at all at Oregon law. Functionally, what this means is if you have a termination document that says it doesn't occur until both of us agree it occurs, or I can take it back at any time, it adds very little to the contract, and it functionally means that your obligations are not frozen. If I send a withdrawable termination, you're supposed to keep acting until we can mutually agree to a termination, because that termination document doesn't operate as a termination. It does not do anything until both of us agree. And so our obligations continue as though we were under a contract with no pall or cloud of a termination over it. That means you may be stuck in a termination if the other party doesn't want to sign the termination agreement, and you can't come to mutual agreement on termination, and you can't unilaterally force the termination. That may mean that you're just stuck doing everything like you were under a regular contract, because the moment you fail, the other party can pull back their termination and put in a real one that's got a valid basis for it. The Oregon Realtors contracts create a unilateral notice of termination. It's not mutual. It's not withdrawable. When you send a notice of termination, you have terminated the contract. There's one exception to this, which is where a seller is terminating. A buyer can theoretically pursue what's called specific performance, but that essentially just operates as a buyer's right to undo a termination through court order. For all intents and purposes, when a party sends a notice of termination, the contract is done. The Oregon Realtors contracts will tell you when and how you are allowed to terminate. For instance, this piece from the sales agreement, if the proof of funds is not delivered, the seller can terminate. And they do so by providing buyer form 5.4, the seller's notice of termination. And in that seller's notice of termination, it will say all the earnest money goes back to the buyer in that scenario. So if the proof of funds is not satisfactory or they don't get it, then the buyer gets the earnest money back, but you're out of contract. And then you would send a seller's notice of termination. You would specify the buyer failed to provide proof of funds. You would check the box that provides exactly the reason for it. So you would sign and date the notice of termination, give it to the other party, and check your reason for that termination. You have to give escrow some details, so escrow needs to know when you terminate, the seller sending the termination, hey, buyer, $4,000 of earnest money is supposed to go back to the buyer. Here's the escrow company, here's the escrow officer, here's the escrow number for that account. We should really get that back to the buyer. And then the buyer has to respond to get escrow instructions. Under Oregon law, ORS 696581, escrow can't actually refund earnest money until they have mutual agreement from the parties or a court order. So the response by the other party is essentially just to get those escrow instructions that say, here's how both of the parties believe escrow instructions should operate. If the buyer's instructions and the seller's instructions don't agree with one another, you've got a dispute that can only be settled through arbitration, mediation, small claims court, or agreement of the parties. And that's disappointing, but that's just how it goes, and that's a result of Oregon law. The contract still gets terminated. It's escrow that we have extra questions about. If the parties agree in their escrow instructions, the seller's notice of termination and the buyer's response to the termination both say here's where the earnest money should go, your contract is terminated and escrow can send the money out. The sixth issue that we tried to fix in the Oregon Realtors forms is with regards to minor breaches. There are all kinds of performance obligations in contracts that do not establish material reason to terminate the contract. The simplest example is a mailing obligation. You need to send me notice. Why don't you send it by USPS? If I send it through FedEx, if I hire a courier to bring it to you personally, I've breached the contract, but you still got the notice like you were supposed to, so no injury has been had. Those are minor breaches. They don't move the contract in any earth-shaking way, but the person wasn't following the exact words. Here's our scenario. You got a buyer who puts an offer on a modern house, a very modern house that is just alive with smart home features. The refrigerator, the washing machine, the microwave, everything is smart features. The seller identifies several of the smart feature systems, but they refuse to provide any more information. They basically say, I'm only going to give that stuff to you at closing. And the buyer disapproves of this and then demands that information. They say like, no, you according to our contract that you signed, you were going to give me information about the smart home features like 10 days before closing so I could figure out how to integrate my life into this. And the seller continues to refuse. Absolutely not. I refuse to do this until closing. I know what I signed, but I don't agree with it now. Upon second thought, I'm really uncomfortable with giving someone information about my smart door system or my smart fridge because they might know about rotten milk in the back or whatever it ends up being. The seller just refuses. So the buyer sends a termination notice and they say, I will withdraw this termination notice if you give me the smart system information. They use it as a tool of negotiation, essentially a way of drawing out the information from the seller. And the seller goes, correct, and signs the termination agreement and goes with a backup buyer. You didn't know about the backup buyer as the buyer, and you go, oh no, I just lost my offer because I used a termination agreement as a point of negotiation. Termination agreements, the withdrawable mutual termination agreement, it's not a toy. It's not a tool for negotiation. If you send one, be prepared for the other party to agree to it. It is brinksmanship. For minor breaches, for little issues that you want to get fixed, a zero-sum game document is not going to be successful. You sometimes just want the person to do the thing, but you aren't so upset about it that you're willing to end the contract. What you don't want to do is send a termination agreement expecting it to be a negotiation item and then accidentally have a termination. So instead, what the Oregon Realtors Library did is created the notice of default. A notice of default is essentially a document that says you had obligations. There were things in the contract that you needed to fix. You didn't fix them. I will give you some extra time to fix them. If you don't fix them, I will terminate the contract. I grant myself a right of termination if you do not fix the issue you were otherwise supposed to have already done. That is what a notice of default does. It says you had agreed previously to this item. That item, we'll treat it as immaterial. You still have some time to fix it. But if you don't fix it within this new cure period, that failure is now material. You render immaterial defaults material. If someone sends notice by USPS and they were supposed to send it by FedEx, I can send a notice of default and say, you have to send that document by FedEx. You did it wrong. You were supposed to do it in a very specific way. Now the other party knows they can send the document, and if they do send the document, they'll be back in compliance. They can follow the rules like they agreed to originally, and if they fail to do so, the other party has a right of termination. Now, the right of termination does not have to be acted upon. You can, but do not have to use it. If you do send a notice of default, an opportunity to cure, you get to specify how long the party gets to fix the thing. Could be 3 business days, could be more than 3 business days. You could give them a week if it's a complicated issue. And then you'll specify the item they need to fix. Hey, seller, you did not provide the association documents like you were supposed to. I was asking for the association documents in physical print format because I don't have a computer that can run PDFs. I just don't have one. So I need you to send me physical documents. You sent me a USB drive. I can't access it, so I need those documents. I'm sending a notice of default. Please do exactly what you agreed to originally and send physical documents. Having one of these defaults sent essentially forces the other party into making a compliance decision, trying to render themselves into compliance with the contract as they originally bound themselves. Now, if you do send a notice of default, have a hard conversation with that client. Okay, client, we're sending a notice of default. What happens if the other party does not meet the obligation? What happens if they don't fix it? What if they say, no, I sent you the HOA documents by a computer that has a USB drive? If they say that, maybe you terminate, maybe you don't. You can use a notice of default as a cattle prod to try and get somebody to move and do the performances they said they were going to, and you don't have to terminate, but have a conversation with your client. Is this thing so important to you that if it is failed, if it is uncured, you do wish to terminate? If that's the case, great, we can terminate at the end of the cure period, but we don't have to. Issue number 7, professional inspections. The scenario is that you have a buyer and a seller who are under contract. The contract has a list of professional inspections that you can opt into. And the buyer doesn't know really what they're doing, so they just say, I want a general home inspection. But they say no to everything else. So the list is like home inspection, pest inspection, dry rot, radon, and all those other things. And the buyer says yes to the general home inspection and no on everything else. During the general home inspector, the inspector says, hey buyer, you see that over there? I am not qualified to tell you if this is a problem or not, but you might have some pests going on here. Like that could be infestation. So you need to get a pest inspector in here who knows about specifically this stuff, who can tell you exactly what you're dealing with here. Great. Buyer goes back to the seller and says, seller, my inspection turned up some other stuff. I need to do a pest inspection. And the seller says, no, you already said I will not do any other inspections. You already said no to pest inspection, and I'm holding you to your own contract. Whenever you ask a party to initially specify what they need, that's going to cause disagreements in the future. If you're asking someone to designate what specific items of inspection they need at the start, and they don't know about the property, they don't live there, they don't know what the possible issues are, there are going to be some possible problems that can arise. Buyers don't know what they need to ask for when they start asking for inspections. That gives them loose options, and none of them are good. They can either ask for every single possible invasive inspection with their offer. Hey, seller, I need a radon test, a well test, an oil tank locate. I need all of this on the off chance that maybe I need these things. But that makes the buyer's offer much worse, and that's not great for the buyer. They can alternately ask for just the reasonable invasive inspections. Hey, I might have to do a pest inspection. I might have to do a dry rot inspection. Gosh, I hope I don't have to do radon. We'll see what else I need, but I'm hoping I just kind of threaded the needle and guessed appropriately. And that's fine, but the buyer has to just take a stab in the dark and hope they're right. Or they can ask for no invasive inspections and just hope upon hope that nothing goes wrong with the property, that there was no need for invasive inspections. And that's not great either. So the buyer is left between a rock and a hard place where they have no good options. They either make a materially much worse offer, or they make an offer that has guesswork at best at what they would need into the future. The Oregon Realtors forms tried to address that by modifying the inspection contingency, the due diligence contingency in our forms. In the contract, say there are some things a buyer is allowed to do. You can do sewer scopes, mold tests, pest inspection, dry rot, radon, and oil tank locates without having to ask for permission. They are not considered invasive inspections. They're just inspections you can do as a buyer. If the seller doesn't want to permit those, you can remove those from the contract. The seller can say, buyer, you are not allowed to do pest inspections. Put that in the offer. The seller can make that specification. However, from the buyer's perspective, that is quite telling. If the seller says you're not allowed to look for pests, that tells the buyer something. Vast amount of other inspections still are invasive, still require additional approval from the seller. If you want to do an asbestos test, where they're literally taking a souvenir from the house and sending it to a lab to see if there's asbestos, that is going to be invasive. You need seller approval. But for those commonplace inspections, sewer scopes, mold tests, pest inspection, dry rot, radon, oil tank, those things you can just do if you have an Oregon Realtors form. The way that you would generally operate with this form is you would have the buyer hire their inspector to do their inspections. The buyer has their due diligence period to get all these things done. They need to give the seller reasonable notice before they do these inspections. The seller needs to provide reasonable access. Tenants shouldn't be disrupted in a big way. And if the inspection that the buyer does in the first day of their due diligence contingency triggers some need for another inspection down the road, 3 or 4 days later, you get the pest guy out to go and look for pests. Congratulations. Schedule it with reasonable notice to the seller. You'll get reasonable access. You can do those things. There's nothing inherently wrong or stopped. There's no prohibition on the buyer doing these additional tests just because you specified on a list earlier that you were not going to need it when you were just taking a stab in the dark. Instead, Oregon Realtors forms say, for these specific things, have at it. They are not invasive. Even though they might be considered that under some schemas, under our form, they are not invasive. The other issue we cover in the Oregon Realtors forms is regards to wood stove removal repairs. So here's your scenario. You have a seller who's selling a home that has a wood stove. It's one of those very old wood stoves that is inefficient and dangerous to the air around it, and the EPA wants it removed. The seller is supposed to remove that wood stove at closing. Per the contract, per the Clean Air Act, per the EPA and DEQ, they have to get rid of this wood stove because it is a disaster. Seller removes the wood stove. They take the stove away. It has a stovepipe that leads up into the open air above the house. The seller just yanks the stovepipe down, and that leaves a hole in the ceiling, a nice perfectly circular hole in the ceiling, and the seller doesn't do anything about that. They just stuff a couple t-shirts into it to keep the rain out. This is a literal thing that happened to brokers in the state of Oregon. Buyer walks in on day one, and they see their house, this new house they were so excited to purchase, and there is a hole in the living room ceiling that has t-shirts stuffed in it. The contract only required the seller remove the wood stove. It didn't say you had to fix the hole that was left behind, just said take the wood stove out. The seller did exactly what they needed to. They have literally followed the contract. They may not have followed the spirit of it, but they followed the letter, and they are not wrong by the exact terms of the contract. The t-shirt hole that's going to very much upset your buyer is a pretty reasonable thing as far as the contract is concerned. So the buyer's first angry question will always be, hey, agent, why is there a hole stuffed with soggy t-shirts in the ceiling? This seems like a huge issue. Well, the wood stove addendum, it never really addresses what the parties are supposed to do when the stove is removed. It never says when you remove the stove, also fix the hole. Then it doesn't require a fix. If the contract generally presupposes that there's some nice, easy, like lift the fireplace insert and remove it, but that's not necessarily the way it's always going to work. If you have an inefficient wood stove that actually has a stovepipe, there's sometimes going to be a hole in the ceiling that no one ever addresses, or there's going to be carpeting around the wood stove at the floor that's just missing. A large wooden space or a bricked out space on the floor that has nothing there. So you do need to consider those problems. And so in the Oregon Realtors forms, we do have in the wood stove addendum, hey, is there an inefficient device that has to be removed? Yes, no. Okay, if yes, does the seller plan to repair any damage caused by the removal of that inefficient device? If the answer is yes, they plan to remove it, then that's a seller obligation. There should be no t-shirts. If they say no, then you, the buyer's agent, can at least start explaining to your client, okay, so the seller's going to remove the wood stove, but just be aware, they don't have to fix any of the things that are caused by that removal. If removing the wood stove leaves a hole in the ceiling, there's going to be a hole in the ceiling. Maybe you can put in a skylight. If the seller is removing the wood stove and they aren't doing anything about the brick base, you may just have a living room with a weird square brick base in one of the corners of the room that's just irregular. If you want them to remove the bricks and put in carpet, if you want them to fix the ceiling hole and shingle it over, you have to ask for that. Another issue we cover in the Oregon Realtors forums, the concept of abandoned belongings after closing. Here's your scenario. The buyer purchases a home from the seller. After you get the keys, the buyer walks into the new home. They have a smile of joy on their face because they just bought a home, and the first thing you see is a literal pile of garbage that was left behind by the seller in the rush at closing. The seller just couldn't get around to emptying out that giant pile of garbage in the middle of the living room. It happens. Scenario where it's more common place with is like an estate that sells a house that they don't want to have to deal with the full closing of the property and cleaning it out. They just leave everything behind because it's not their problem. For the buyer, that's sometimes a problem. The buyer's not pleased by that. Oftentimes, the listing agent and the buyer agent will both hear from the buyer in those situations, and the buyer will demand that the agents clean it up at their own expense. You're not technically required to do that. It's not wrong to do so. It's a nice, good Samaritan thing to do, but there's nothing at contract law that would require the agents to go and clean up the house afterwards. Generally, if your contract is silent on the cleanliness of the property at closing, or otherwise tells no further steps to the parties, the buyer needs to fight in a court of law to basically argue over why that pile of garbage in the house is problematic or why they've been injured. The Oregon Realtors forms document added a provision that says, seller, clean the building and its interiors and remove trash and debris from the property before you close. If you remove fixtures, fix the surfaces that have been damaged in the process of removing those fixtures. If there is some other agreement for possession of the property, you'll remove your stuff at the end of that possession date. If there are items that remain on the property after closing, those belong to the buyer. If the buyer has to pay for removal of those items that you've left behind, the abandoned stuff, the buyer can pursue those costs against the seller. It provides at least an avenue for getting a lawsuit with the seller to get the expenses of hiring service to come and clean it out, or getting a dumpster and cleaning out yourself. The seller can modify this provision with a general addendum if they do plan to transfer like a truly filthy house, but the default is seller, you're going to clean the house before closing, and you're not going to leave any stuff behind. If you do leave stuff behind and it's valuable, it belongs to the buyer. If you leave stuff behind and it's an expense, a debt, then the seller can pursue the cost of that disposal from you, seller. Another issue we cover in the Oregon Realtors forums, let's imagine you have a smoke detector in a house that a buyer wants to purchase. House gets appraised. During the appraisal, the appraiser notes that there is no smoke or CO detector that was otherwise required by law. And they go, sorry, we can't actually fund the loan on this house until it is compliant with law, which means because it's not following fire codes, we can't fund the loan. You're going to have to bring another appraiser back later on just to make sure that the smoke detectors, fire alarms, and CO detectors, they are present. So the buyer has to shell out more money for the second appraisal because the house has no smoke detectors. At the second appraisal, the guy's like, yep, smoke detectors are there. Check, Roger, that's there. And that's the whole appraisal. That happens. So it creates problems because the buyer is bearing the cost of that, what amounts to a seller obligation. It is the seller's job to make sure that the house is up to code. But the buyer is the one paying for the lender's appraiser in most situations, or is paying for the inspector to come in to help with their loan process. Basically means it's a seller obligation, but the cost is on the buyer. Fire codes apply to the seller. They need to make sure their house is up to code before they transfer the property. The buyer is also stuck in the same place. Oregon Realtor forms say seller if there is a second appraisal that is required, a second inspection that is required because you didn't put in enough smoke detectors or enough carbon monoxide detectors. You are responsible for the expense of those detectors. You got to pay for it. The buyer doesn't have to pay for the second one because it should have been fixed upon the first appraisal. It should never have been a problem in the first place. Another issue we try and cover in the Oregon Realtors forums is expired offers. So your scenario is you have a buyer who has an offer that they give to the seller and it expires on the 6th of January. That's when it's done. The seller forgets about it, doesn't even look at it until the 7th, and then go, oh, that's a great offer, I accept. On the 9th of January, the seller accepts the offer, and the buyer just kind of shrugs and goes along with it because they didn't have a better offer on the house at that. They didn't have any other choices. They're like, oh, it's good enough. So they just move forward with it and they're happy with it. Well, at some later date, the buyer finds an even better house. They keep looking around online on the listings and they're like, wow, that one's way better for my needs. I don't want to buy this house anymore, but I want my earnest money back and I don't have a great reason for backing out. So the buyer then does a novel thing. And they say, actually, seller, my original offer had expired before you accepted it. So under law, that's void. You can't have a contract based on an expired offer. So I don't think I'm under contract with you anymore and I want out and I think I should have full rescission. You should, no earnest money is retained by the seller. I get everything back. And the buyer's probably right. Under law, offers have to be accepted before they expire. If an offer expires, it's no longer valid. It's void at law under the statute of frauds. What that means is accepting an offer that has expired creates this really permanent fault in the transaction. You've created a zombie contract of some sort. When you've revived a contract from the state of being void, it's arguably voidable for the full remainder of the transaction. You can argue that it never should have existed. And unless you have some sort of a contract memorandum that reestablishes the validity of the contract after the fact, it's going to remain void if you don't put other things in. Even if you do have some other piece of writing that renders it valid under the statute of frauds, it's still probably void for the period of time between when it expired and when the parties actually put something in writing, and that creates a full question of law that is really unaddressed in Oregon. So we generally discourage you from entering into a zombie contract if possible. Avoid them in general. And the way that we tried to fix that in the Oregon Realtors forums is by saying you can only accept an offer before it expires. Once it's expired, you need a full new offer. It needs to be something fresh. Form 2.3 is for late offers. You missed it, sorry. It's a pre-drafted counteroffer. It essentially does exactly the same thing as a counteroffer, and you counteroffer it anytime regardless of when an offer is expired or not. But it does the exact same thing as a counteroffer and says, here are my terms to you. I'm sorry I missed your original offer. My bad. My counteroffer is all the same terms you just gave me, but the expiration date is now later. Do you accept or not? It trades the ability to accept the offer. So in this situation, the seller can't just unilaterally accept an expired offer. They have to instead go back to the buyer on bended knee and ask for the buyer whether they would like to remain under contract. But if the buyer signs a late acceptance addendum, essentially a pre-drafted counteroffer, you have a new valid offer that is not expired. It's fully compliant with the statute of frauds. There are no problems at law. So you can use this new offer to keep yourself legally and contractually compliant. The way you would essentially use this document is if you present your offer and it expires, the seller would then send the late acceptance addendum and say, hey, I got your offer. It expired. My bad. Would you like to stay under contract on the exact same terms you gave me earlier? We just have a different expiration date, which has not passed yet. And if the buyer agrees, congratulations, you're under contract. No problem at all. There is no ability to have a change of heart. There's no ability to claim that the contract was void because you've entered into a valid new offer through use of that late acceptance addendum pre-drafted counteroffer. And those are some of the reasons why we changed Oregon Realtors forms to try and address problems that had arisen in the past. If you have other things that you think are interesting or things you would like to see changed in the forms, please let us know. We try and change them all the time to address situations just like these.